बिस्मिल्लाहिर्रहमानिर्रहीम अस्सलातु वस्सलाम अलैका या रसूलल्लाह वस्सलाम अलैका या हबीबल्लाह। प्यारे व्यूअर्स, मैं हूं मलिक फयाज अहमद वर्ड एडवोकेट हाई कोर्ट और आप देख रहे हैं मेरे यूट्यूब चैनल। और मेरी आप तमाम दोस्तों से गुजारिश है कि आप मेरे जो नए दोस्त आने वाले मेरे नए दोस्त हैं मेरे वीडियो पर, उनसे मेरी गुजारिश है कि मेरे इस चैनल को सब्सक्राइब कर लें, घंटी और लाइक के बटन को दबा दें ताकि मेरी हर नई आने वाली वीडियो आप तक पहुंच सके और आप इल्म हासिल कर सकें। और जुडिशल एग्जामिनेशन के हवाले से मेरी वीडियोस बहुत अहम हैं। और ये जो आज का टॉपिक है ये एग्जामिनेशन के हवाले से बहुत अहम है। मेरी आप तमाम दोस्तों से गुजारिश है कि मेरे वीडियो को शुरू से लेकर आखिर तक देखें, आप तमाम दोस्त इससे मुस्तफीद होंगे। आज का मेरा जो टॉपिक है, ऑफ द ट्रांसफर ऑफ क्रिमिनल केसेस, सेक्शन 526। हाई कोर्ट में ट्रांसफर केसेस आर itself try it. Whenever it is made to appear to the High Court, A. That a fair impartial inquiry or trial cannot be handed in any criminal court subordinate thereto, or B. That some question of law unusually difficulty is likely to arise, or that a view of the place in or near which any offence has been committed may be required for the satisfactory inquiry into or trial of the same, or D. That an order under this section will tend to the general convenience of the parties witnesses, or E. That such an order is expedient for the ends of justice or is required by any provisions of this code. It may order. E. That such an order is expedient for the ends of justice or is required by any preposition of this code. It may order. Number one, that any offence be inquired into or tried by any court not empowered under this section, section 177 and section 2184, both inclusive that in other respect competent to inquire into or try such offence. Number second, that any particular case or appeal or classes or appeals be transferred from a criminal court subordinate to its authority to any other such criminal court of equal or superior jurisdiction. Third, that any particular cases are appealed to, transferred to and tried before itself, or fourth, that an accused person be sent for trial to itself or to a court of session. फौजदारी मुकदमात की मुंतकली, सेक्शन 526 हाई कोर्ट में मुकदमात की मुंतकली या खुद इसकी कोशिश करें। नंबर वन, जब भी इसे हाई कोर्ट में पेश किया जाए कि एक गैर मुनसफाना गैर जानबदाराना इंक्वायरी और ट्रायल वहाँ के मातहत किसी भी फौजदारी अदालत में नहीं किया जा सकता, या गैर मामूली मुश्किल के कानून का कुछ सवाल पैदा होना पसंद है, या कि इस जगह का नज़ारा जिसके करीब और जुर्म का इर्तिकाब किया गया है इसकी तसल्ली बख्श इंक्वायरी या इसकी पगडंडी के लिए ज़रूरी हो सकता है कि इस दफ़ा के तहत ऐसा जुर्म 10 के तहत फरीकैन या गवाहों की आम सहूलत के लिए है कि ऐसा हुक्म अदल के खात्मे के लिए मुफीद है। नंबर दो, when the High Court withdraws for trial before itself any case from any court, it shall observe in such trial the same producer procedure which that court would have observed if the case had not been so withdrawn. Number 3, the High Court may act either on the report of the lower court or on the application of a party interested or on its own initiative. Number 4, every application for the exercise of the power conferred by this section shall be made by motion which shall accept when the applicant is the Advocate General be supported by affidavit or affirmation affirmation. Number 5, when an accused person makes an application under this section, the High Court may direct him to execute a bond with or without sureties, conditioned that he will, if so ordered, pay any amount which the High Court may, under this section, awarded by him a way of compensation to the person opposing the application. Number 6, notice to public prosecutor of application under this section. Every accused person making any such application shall give to the public prosecutor notice in writing of the application together with a copy of the grounds on which it is made, and no order shall be made on as elapsed between the giving of such notice and the hearing of the application. 6a, where any application for the exercise of the power conferred by this section is dismissed, the High Court may, if it is of opinion that the application was frivolous or vexatious, order the applicant to pay by way of compensation, or any person who has opposed the application such sum not exceeding 500 rupees as it may consider proper in the circumstances of the case. Number 7, nothing in this section shall be deemed to affect any other order made under section 197. It in an inquiry under chapter or any trial, the fact that any party intimates to the court at any stage that the intends to make an application under this section shall not require the court to adjourn the case, but the court shall not pronounce it final judgment or order until the application has been finally disposed of by the High Court. And if the application is accepted by the High Court, the proceedings taken by the court subsequent to the intimation made to it shall, at the option of the accused, be held afresh. Number 10th, if the before the argument, if any further admission of an appeal begins, or in the case an appeal admitted before the argument for the applicant begins, any party interested intimates to the court that he intends to make an application under this section, the court shall, upon such party executing, if so required, if bond without sureties of an amount not exceeding 500 rupees, that he will make such application within a reasonable time to be fixed by the court. Postpone the appeal for such a period as well, afford sufficient time for the application to be made and an order to be obtained thereon too. आज तक के लिए बस इतने इंशाल्लाह कल मिलते हैं एक नई वीडियो के साथ और अल्लाह ताला आप तमाम दोस्तों का हामी और नासर हो। पाकिस्तान जिंदाबाद, पाकिस्तान आर्मी जिंदाबाद। अस्सलाम वालेकुम।